Thanks very much, everyone, for coming to this TOEIC Appeals Post-Varkey Lessons from the Post Office Scandal. We're going to look at the judgment from Varkey and Joseph, which is almost a year ago now, and offers hopefully some insights into what happened, first of all. I mean, almost like you would in an inkfest, and then what needs to happen going forward in cases raising the same kinds of issues. I am going to be speaking first. I specialise in, my name is Ó Ceallaigh. I'm a barrister at Garden Court. I specialise in immigration, asylum, human rights, civil and public law. I've over 15 years experience in that, and I've been doing TOEIC cases for over 10 years since I met Nabil Hassan in an interview in Birmingham with M&K solicitors, where I spoke to him for the first 15 minutes thinking he was the solicitor because his English was so flawless. And the idea that he would have cheated in an English language test is the stupidest idea that I ever heard. And since then, I've been heavily involved in these cases, and I feel very strongly about them. My practice is based on appeals, but also on trying to right wrongs that have been meted out against migrants in this country and secure them compensation where the power of the state has been abused. Patrick Lewis is also going to be speaking. He's another barrister at Garden Court. He specialises as well in asylum and immigration, human rights and public law. He's ranked in Chambers Partners. He's ranked in Legal 500. He's been appearing in the tribunal since 1992, was called in 1997. He's represented a full range of immigration, asylum appeals and applications. He's been working on the TOEIC cases for longer than I have. He was asked to appear before the all-party parliamentary group in TOEIC. He gave evidence of that and on the legal issues arising. He's given various media interviews on the subject, including with Newsnight, and he continues to successfully represent TOEIC appeals and judicial review challenges. Alex Schymyck is a barrister at Garden Court. He's ranked as a rising star in the immigration by Legal 500 and also by me. He acts in immigration proceedings of all kinds and routinely acts unled in the High Court and the Tribunal in urgent applications concerning immigration detention and removal. He's active in the Brook House inquiry. He's currently in the Cranston inquiry, and he was junior in the Varkey case. Abby Buttle was my pupil during the Varkey case, and she worked heavily on these cases and knows it really well. She's now a tenant is building a broad human rights, public law and civil liberties practice, specialising in immigration, education and community care. Abby acts regularly in statutory appeals, bail applications in the FTT, and she has done inquest and inquiry work. Shana Shaikh is hopefully going to be joining us. She's going to be a little delayed for reasons that Patrick's going to go into. Shana is an Indian national who's wrongly accused of TOEIC fraud. She's been fighting to clear her name since 2016. She's awarded an MBA degree by the University of Wales and has passed other English language tests to a level significantly higher than that required by the rules. And she continues to fight to clear her name, as many people still do. I am going to go first to explain the Varkey situation. Thanks, folks. So what we're going to cover is, I'm going to look at the decision in what happened in Varkey. I'm going to give a little bit of context to TOEIC appeals for those who aren't familiar with them already. Patrick is going to talk about conducting appeals following the Varkey decision. Alex is going to talk about the evidence of the Varkey case. Shana is going to tell us a bit about the experience of being a TOEIC victim, and Abby is going to talk about the Post Office scandal. But just to be clear and explain why I wanted to run this event, first of all, it's because, in my view, I'll get into this in more detail as we go, the most significant thing in the Varkey case wasn't the result and wasn't the determination. It was the evidence that was disclosed, which in my view is of enormous significance for these cases going forward and for hopefully for clearing people's names. And we wanted to get that into the open because it's not immediately obvious in the determination. So the history of the TOEIC scandal, for those of you who don't know, some of you will know very well. I think we have some people who were involved originally in the room. In the broadcast. On the 10th of February 2014, the BBC broadcast an episode of Panorama showing extensive cheating was taking place in educational testing service centres offering the TOEIC test. There's no question that cheating was happening and on a significant scale, and it's absolutely clear from the Panorama evidence and from the subsequent criminal convictions. It was a Home Office approved testing centre, and the Home Office had been aware of problems for some weeks before it aired. Now, at that stage, 2 Home Office civil servants went to the United States to speak to ETS, effectively looking for an explanation and a way to tell who was cheating and who wasn't. And they were given a list, effectively. They're given details of all tests taken, split into 3 lists: invalid, i.e. a cheat was involved, questionable and released. Now, when I say invalid, i.e. a cheat is involved, it's very important to note that the position taken by ETS was an invalid test is one that cannot be relied on. That's what you'll get in your letter from ETS in any ETS appeal. The Home Office will say that means a proxy was used. And the evidence for that is they say a civil servant in America told me that that means a proxy was used. You will never get ETS to directly say that your client used a proxy. And I think it's because they're not sure about it, and certainly they're not prepared to put their neck out. A test result is described as invalid where the same voice appears on the voice file for multiple tests, which is said may indicate the presence of a proxy taker. But again, what you'll get from your letter from ETS is there are anomalies in your test and you can't rely on it. A total of almost 60,000 TOEIC tests were taken between 2011 and 2014. Of these, 56,000 were deemed to be either invalid or questionable, which is a stunning figure. The Home Office curtailed or refused further leave to remain for at least 34,000 people. That was a figure was corrected in 2019, but you're still getting people coming through the system, although not very many. The Home Office treated in all cases without exception an invalid test certificate as determinative of guilt, whatever other evidence there was, in all cases. They also had a policy, Operation Agentuk, which has never been disclosed, but is you'll see referred to in internal case notes all the time. They said this is an Operation Agentuk case, and therefore what they would do is they would make a decision to curtail leave, but they wouldn't tell people that they were going to do it. They would then they would go to people's houses and try to serve it on them in person. That would prevent them making an application for further leave that might trigger a right of appeal. So the initial attitude was, if somebody had made a human rights claim, he's certified as clearly unfounded to prevent a right of appeal in country. If they hadn't yet made a human rights claim, you would hide the fact that you considered them to be a cheat until you could serve the decision on them in person, so they'd only have an out-of-country right of appeal. And in quite a lot of cases, what they do is they wouldn't say anything to you at all. They go to your university, tell your university, this guy's a cheat, kick him out, and then they'd write to you and say, well, whatever is going on between you and your university, you're not studying anymore, therefore you can't leave to remain anymore, thereby avoiding again a right of appeal where their evidence will be tested. The courts were initially quite supportive of the Home Office position, and repeatedly found that an out-of-country appeal was an adequate alternative remedy. Now, we're sitting here in 2025, and we are all used to having meetings on Zoom, and quite a lot of court hearings are now held on Zoom. But in 2014, the idea of running a case remotely over Zoom was for the birds. It was something that basically didn't exist. And in substance, an out-of-country appeal was very, very difficult to run, and was no appeal at all. Courts were also initially very supportive of the Home Office position on the strength of its evidence. However, there were then a series of critical judgments. So first of all, SM and Kadir, where the Home Office's generic evidence, the generic evidence being the statements from the two civil servants whose job it was, incidentally, to run English language testing in the UK successfully, who came back and said, oh, actually, look, we've got a list of all the bad people now. That evidence, plus the fact that a person was on the list, was considered to raise a case to answer only by a narrow margin by the upper tribunal, which said it had multiple frailties and shortcomings. In the Assan case as well, Mr. Assan I referred to earlier on, it was held that it wasn't an adequate remedy for the purpose of the common law or for Article 8 to have an out-of-country appeal, and also that those appeals could not be certified properly as clearly unfounded. SM and Kadir, really important staging post. The upper tribunal found none of the Home Office witnesses had any qualifications or expertise in the scientific subject matter of the appeals. Now that, of course, was quite a long time ago. That was 2016. That's absolutely still the case. You still don't get any Home Office evidence from qualified people. The Home Office was entirely dependent on the information provided by ETS, much of which was delivered orally rather than writing. Literally, I went to America and we had a meeting and they told us all of these people are cheats. ETS was the sole arbiter of the information disclosed and assertions made to the Home Office's delegations in the United States. The Home Office staff uncritically accepted everything reported by ETS, which they still do utterly faithfully, despite having sued them because of how badly the English language testing system was handled by ETS. The Home Office at no material time had advice or input from a suitable expert, and there were no evidence from any ETS witnesses, a record that remains unblemished to this very day. The test results that 33,000 suspect Test scores, coupled with information disclosed and assertions made, constituted the totality of the material. That was the whole lot. The tribunal held that while the judgment in Gadi had raised significant questions about the witness statements of Ms. Collins and Mr. Millington, the two civil servants, these were not addressed, much less answered. Then we had a series of test cases heard together, Mohibullah, MA, and Saha. The individuals in these cases were the first to have their voice clips provided. So before that, for years, people were saying, look, can we please have the voice clips relating to our test? Because my voice will be on my test. It's extraordinary the number of clients who were absolutely adamant that was the case. And of course, when the voice clips arrived, none of them were. I've only ever seen one case where the voice was actually on the voice clips. So you find that before those cases, we were demanding and the Home Office was saying, you can't have them, it's impossible. And then for years after that, in any appeal you had, the Home Office would say, well, it's deeply suspicious that you haven't asked for your voice clips until 2017. Anyway, there were 3 IT experts, Richard Highway, Chris Stanbury, and Professor Summer, and they prepared a joint report, and the report identified major concerns in the evidence. For a start, the reliability of the allegation depended in all cases on the quality of information provided by ETS to the Home Office and the ability of the Home Office to match this with the data from other sources. The integrity of the test-taking procedures and systems established by ETS depended heavily on the reliability and probity of the test centre staff. That was an important issue in Varkey. But basically, the test-taking procedures and systems depend entirely on the people who are running the fraud, and to give you an indication of how reliable they were. ETS security precautions were concentrated on the conduct of candidates and basically just assumed that all the employees will be acting honestly. There was no metadata on the voice files that allowed them to be reliably traced to the point they were made, and that's still the case. It was not possible then, and it's not possible now to see how accurately individuals were linked to tests. It was noted there were a range of possible methods in which cheating could have taken place, simple impersonation, i.e. swapping in and out, team viewer software, remote control mechanisms, file manipulation, i.e. somebody messing around with files on a computer, or a hidden room replacing speaking files without the knowledge or consent of all students. The experts consistently complained they've been limited by the quantity and quality of material available to them. The tribunal found that there were enduring unanswered questions and uncertainties relating in particular to systems, processes, and procedures concerning the TOEIC testing and subsequent allocation of scores, the later conduct and activities of ETS. Then we get the National Audit Office report, which shows a deeply questionable percentage of people being accused. Then we get the report of the All-Party Parliamentary Group on the 18th of July. The experts agree that the evidence provided by ETS contains fundamental flaws. The majority of experts considered decisions couldn't be taken on the evidence of ETS alone. The Home Office had disregarded anomalies in the evidence and the lack of chain of custody. And Alex will talk a bit later about the anomalies. The Home Office had consulted experts at a meeting in August 2014 as to whether its evidence was robust. The experts had said they needed further evidence to answer that question. That evidence was never supplied. Professor French, who the Home Office relies on all the time, cautioned against using the report as a sole basis on which to conclude there had been fraud in any individual case. We had further press attention, and then of course we had the prosecution of some of the criminal gangs who were running those test centres. The Public Accounts Committee says in September 2019 that the Home Office was quick to act on imperfect evidence, was slow in responding to indications that innocent people may have been caught up in its actions. The Home Office's decision to revoke the visas of thousands of individuals before properly verifying evidence provided by ETS had led to injustice and hardship for many people, which is undoubtedly the case. Now, then we get to DK&RK, which is again a sea change. So initially in the DK&RK litigation, the appellants relied heavily on the APPG and NAO reports to say the Home Office evidence didn't even raise a case to answer. And there was initially a decision which decided that those reports were not admissible for the truth of their contents in themselves. But the real issue was DK&RK2, where the upper tribunal gave the Home Office evidence complete clean bill of health, a complete contrast to with the clear circumspection with which the tribunal had earlier regarded the Home Office evidence. They now said the evidence currently being tendered on behalf of the Secretary of State is amply sufficient to discharge the burden of proof, and so requires a response from any appellant whose test entry is attributed to a proxy. And DK&RK considered the usual generic evidence, so the evidence of the civil servants, the fact that you're on the list, the voice files, bearing in mind we've no way of knowing how accurately they've been connected to any individual, And then detailed evidence in respect of 2 test centres where there was undoubtedly a lot of cheating happening using simple methods. The only kinds of fraud they considered were swapping in, i.e., you sign in for the test, then I come and take your place, do the test, and then you get the result. And TeamViewer, which is user remote control software. And they said, therefore, any cheating could only have been with the consent and knowledge of the accused. So the key conclusions were, Secretary of State evidence in any particular case is to be considered in the context of the widespread TOEIC fraud. So we start from the position that there's a massive fraud, and therefore there's an inherent likelihood that the allegation against an individual is correct. An extraordinary statement. And then evidence of incompetence in English will show that you're more likely to have committed the fraud. But if you're good at English, that doesn't support the proposition that you might not have committed the fraud. I'm not a leading judge in the way some people involved in these cases are, but a child of 5 could tell you that a person who doesn't speak English is much more likely to cheat in an English language test than a person who is excellent English. Now, it also found in order to establish fraud, the Home Office would have to identify that a voice recording belongs to somebody else, which is a matter of voice recognition, and invariably the voice recording will belong to somebody else. Identify that it had been correctly attributed to that individual, which is a matter of ensuring chain of custody, which is the bit where this has always been a bit circumspect about how well the Home Office evidence can be relied on. And what the tribunal found in DK was generic criticism of ETS procedures and chain of custody were rejected because there was no clear evidence of any problems with the chain of custody, because there's no evidence of the chain of custody at all. And it was inconceivable that ETS would retain the work that they do because thought their administration was in this respect unreliable. So this organisation that had been involved in, if the Home Office case is correct, probably the biggest fraud against the United Kingdom in history, was so reliable that we should assume the processes we can't see are working perfectly. This was a responsible body with a clear interest in securing the integrity of results. Although in an individual case, it remains perhaps possible that a person denying guilt might succeed if their account was credible and sufficiently comprehensive. So, then we got on to Mr. Varkey. This was a direct challenge decision, DK and RK, and that's the way we framed it. That's the way our position was that DK and RK were wrongly decided and needed to be dealt with. We relied on the expert evidence of Chris Stanbury. We relied on extensive new disclosure of what was happening on the ground in ETS cases. And we relied on witness evidence, including from Richard Shurey, the ETS auditor, who was in fact the Home Office witness, as well as evidence of ETS failures internationally. So, Mr. Varkey, he's a nurse, involved him and his wife. He'd been working lawfully in the UK for years. Numerous IELTS tests showing his really good English. He had witnesses who attest to having worked with him at the material time. They gave evidence that he had English to a really high standard, and they gave character evidence that he was in positions of responsibility, he was trustworthy, he wasn't the kind of person who would commit fraud. He had a series of IELTS tests, and the significance of his IELTS tests were not only the fact that he had really high speaking results, but also his IELTS tests showed a pattern of strengths and weaknesses that mirrored his TOEIC tests. So, strongest result in speaking, weakest result in reading consistently all the way through his IELTS tests and in his TOEIC. He had a BA in English literature before he came to the UK. Like, what are you supposed to do? Come on. BA in English literature, then he did an MBA in the UK. This man is obviously capable of speaking English. Does he need to cheat on a basic English language test? No. This is a really interesting factual wrinkle, and he said always that he'd taken the test twice. The first time he took it, he failed. And he went to them and he said, can I have my results? And they said, he went to his college and said, can I have my results? They said, no, you failed. And he said, well, I can have my result sheet. And they said, no, you can't have it. We don't have it. And he said, it was a really basic test. He had no difficulty with it at all. He couldn't understand how he possibly failed it. They told him he had to resit it. ETS has no record of him having sat the first test at all. Now, a reasonable person might look at that and say, sounds like something dodgy was happening, but not necessarily cheating by him. The other interesting thing about it is that the pattern in a lot of TOEIC cases is people who are coming up to the end of their leave to remain. You've got a limited amount of time, and the Home Office always says, well, you had a limited amount of time in which you could get an English language test, and that's why you cheated. But Mr. Varkey had actually left the UK in accordance with his visa. So he got to the end, he left and reapplied for entry clearance. So he had plenty of time to reapply and to do another test. There was no urgency in the same way. And also in that case, the Home Office had obviously had his details since 2014, but had made no allegation for 3.5 years, which obviously made it much more difficult for him to prove his case, because he had to go back years and years. And by the time of the appeal, it was 10 years since he'd done the test. Evidence. We had a totally different evidential picture. We were able to show, based on the evidence that we received, that there were at least six types of cheating. At least 6 types of cheating were happening. That was happening. Some of which involved the knowledge and consent of test takers, and which didn't. Direct substitution, so swapping in, where a candidate books a test and a proxy physically takes it. Remote control, that's a team viewer type situation. A dual monitor we found, which is where there's a hidden room where a proxy does a test, while the candidate in the open room has only a second monitor directly connected to the candidate's PC, but can't actually control anything. It was incredible the amount of different kinds of cheating that we found. Parallel testing. So we found a place where the test is run from 2 manager PCs, one in an open room full of candidates and one in a hidden room full of proxies. And the advantage of that is you just upload the results from the proxies. The other guys do their test on the computer, think they've done a test. Some of them are cheating, some of them aren't. They upload all the ones in the proxies. The people who've genuinely done the test will never know the difference. And the advantage of that is you don't have to turn away genuine candidates. You can let anyone do it, and you can. The cheaters will all pass, but everybody will pass, and nobody will come back and go that they're surprised and go. I did actually once have a client who said to me, a TOEIC client who said to me, I didn't cheat, but I did completely freak out in the exam, and then I did stop talking for a chunk of it, and then when I got the results, I got like 90%. I don't really understand how that happened, but I did do the test myself. I was just expecting to fail it, and then I didn't. Nobody generally comes back to university and says, look, I really failed that test. And you kind of explain how I passed it. It's not a thing that happens. You also have fake identities, which is very straightforward. And then mass replacement of voice files, which is where voice files are reused or recordings are replayed and uploaded during a test. And then it was suggested there were possible other methods. And it totally vindicated what Chris Bamber given. He's been saying for years that most of these were possible. He had suggested the possibility of these in 2016. So the evidence was pretty clear that without specific contemporaneous evidence, there was no way of knowing which method of cheating was happening on a given day. And in some cases, you had colleges that where you had lots of police evidence that there were raids, and you had evidence of people who had actually been proxies. And obviously that's quite helpful in telling what was happening. But otherwise, you didn't. And the reason for that was that the ETS auditing colleges was vastly insufficient to get a clear picture of what was happening. And the evidence on that was absolutely incredible. Because the auditors were being told by ETS to stop auditing so much because of what they were finding. And they were told then to stop putting in writing their concerns and to only put their concerns by phone. Adam Sewell, the Home Office witness, he gave evidence that he thought that mass replacement of voice files was actually happening in Mr. Varkey's college because of the times that the tests were being uploaded. ETS software providers at YBM, we had emails to them, and they just kept saying, well, we don't understand how it would be possible to circumvent our system. And they literally sent an email suggesting that what ETS should do on the ground was just have more honest people running the tests, which, obviously they probably should have thought of for themselves, to be fair. ETS actually actively discouraged representatives from finding out if there's more cheating, and literally because they're worried about imperiling their future contracts. We also relied on evidence of ETS's failures and other important scandals, because a key part of DK and RK was that you could rely on ETS because they were the kind of organisation that would not be responsible for this kind of, they're the kind of organisation reputable, they're the kind of organisation whose processes could be assumed to be reliable. So there was the SAT scandal in England in 2008. Relied on another scandal contemporaneous with the TOEIC one, where the SATs had to be called off in the entirety of South Korea, and also widespread cheating resulting in delays in South Korea and China. And we said, this is clear evidence that ETS is not such an impressive organisation that we can simply assume that the processes we can't see are reliable. Key arguments were, first of all, we relied on the failures of ETS globally. We said, look how badly they've done globally. Look how badly they've done in the TOEIC scandal. And then look at the evidence, Richard Shurey, that says that they tried to hide at every turn what was going on. Maybe they can't be relied on. We can't just assume that that they have correctly connected all of these individuals with the voice files that you rely on. We relied on the fact that the SSHD had taken years to make the allegation, making it much harder to answer. That's a relevant factor in assessing the weight to be accorded to it. We also made arguments about the ability to speak English being relevant. And we relied on the post office case, and we said, assuming the ETS system is reliable without any evidence of reliability at all, was reversing the burden of proof. And of course, we relied on Mr. Varkey's account. And then we got the determination appeal dismissed on all grounds. Mr. Varkey found not to be credible for reasons that, in my view, are quite unfair. For example, they said that the fact that he said he'd done 2 tests when they had no record of one of them was deeply suspicious. PKNRK was entirely endorsed. They said, well, there is lots of kinds of cheating, but test centres adopted the less sophisticated methods available of manipulating test results by working in collusion with candidates. They just decided that. The evidence we had from the ETS auditors on the ground was the auditing was vastly insufficient. There's virtually no way of knowing what was happening in any given test centre. And therefore, the tribunal dealt with that by saying, well, we can just assume that the less sophisticated methods, which required people to be guilty, were in use. We just proceed on that basis. Again, it said, an ability to speak English does not mean that an individual is bound to pass any particular component of the tests. There can be a myriad of reasons why somebody who's a reasonable grasp of the English language might nevertheless cheat in a test. But a person who has a degree in English, why would they cheat in a test? I mean, there might be a myriad of reasons, but why don't you think of one and explain it? Because there aren't any that immediately spring to mind. Chris Stanbury's assessment of what happened, this is extraordinary. But as Mr. Stanbury was bound to acknowledge, it's impossible to say in a particular case what method was adopted by a test editor and whether a particular candidate knowingly participated. That is true. But it was also impossible for the tribunal to say that. And in those circumstances, how can they possibly reach a conclusion that they can safely make this kind of extraordinary, life-changing allegation against an individual? He also said that because it could be assumed that in his case, in his individual case, that the cheating had happened via simple impersonation because there was no evidence that in May 2012 his college was operating a method of fraud that involved parallel testing, which is one of the kinds of fraud that didn't require his knowledge and consent. But of course, there was no evidence of what was happening at a particular time in his college. It could be assumed that the cheating was by means of less sophisticated means. And even if a hidden room was in use, the candidate was likely to be aware of that. So even if their knowledge and consent wasn't necessary, it probably was. And we can just gloss over that. As to the reliability of ETS processes, the issues in relation to the manner in which ETS Global internally addressed concerns regarding the frauds, i.e. telling their auditor not to investigate them because they're embarrassing, does not impact upon the integrity of the audit trail by which the voice recordings were attributed to candidates. And of course, there's no proper audit trail. And then you say, as the tribunal said in paragraph 120 of DKNRK, there remains an absence of evidence that in respect of any test identified, ETS has failed in its duty as an examining board to ensure that the entry examined and attributed to a candidate is the entry made by or authority of a candidate. Of course, there's also no evidence that they've ever succeeded in that duty. There's no evidence at all. The tribunal decides that they can just gloss over that. So, what about the evidence and the possible? So we have a Home Office witness who says that he thinks mass replacement of voice files was happening in my client's case, and he accepts that that doesn't require my client's knowledge or involvement. It just doesn't feature in the judgment at all. It's just not there. And what about the fact, obviously, that his results in all of the unimpugned English tests mirror the result in his TOEIC test? Just not in there, not addressed at all. What about the lengthy legal arguments we had on the importance of the respondent's delay in making the allegation? No, it's not dealt with at all. But the tribunal does go on to say that it's suspicious that he can't remember details of the test taken 11 years earlier. What about the evidence of ETS failures in other jurisdictions, which we've relied on, we've made submissions on, we've produced evidence of? Just not in there, not considered at all. What about the witnesses who came and gave evidence in front of the tribunal about Mr. Varkey's character? Now, he was the kind of person who wouldn't committed fraud wouldn't do anything dishonest. It's not mentioned. Doesn't feature at all. In fact, very little of quite a lot of the evidence and submissions that we put forward just didn't feature at all, and it's as if they never happened. It's almost as if the determination is from an entirely different case, which is the lawyer isn't a great feeling when you open that. So we applied for permission to appeal and we refused, and then we tried to reopen. I've never actually applied to reopen a decision, refused the permission from the Court of Appeal before, but we did in this case, and it was refused. So the significance of the Varkey family, of the Varkey case, and this is why I wanted to have this, is why I wanted to have this meeting this evening, and to get as many people to come as possible to understand this. Obviously, it's a personal tragedy for the Varkey family, and it is. It took years and years of fighting, and the result was, in my personal view, a miscarriage of justice, and a serious one, the most serious one I've ever been involved with. However, the wider significance, in my view, is not the result, but the evidence obtained, because the evidence is, in my view, extraordinary. It's now clear beyond argument that the TOEIC fraud happened on the ground in numerous ways. It is, in my view, virtually impossible to tell at this removes the type of fraud that was undertaken on the day, or what type is more commonly in use, unless you have contemporaneous evidence, which there will be in some cases, but very frequently isn't. And so there's also home office witnesses accepted. Some of those types of fraud could have, and almost certainly did, sweep up innocent people in them. And that's assuming, that's just looking at the types of fraud. That's not even looking at the chain of evidence issues. As in the post office cases, there has been a blind assumption of the reliability of invisible processes, which is extremely dangerous. Unlike in the post office cases, where there was eventually evidence of processes being unreliable, there's no evidence at all of unreliability. I mean, one of the things that the tribunal said in our case was, well, in the post office cases, there was evidence of glitches in the system. You don't have that. And we don't have any evidence about the system at all. Literally nothing. They've decided to assume that it's completely reliable, despite everything else we know about ETS. And the key lesson of the Varkey evidence is, in my view, this: the actions of ETS were not the actions of an organization whose accounts can be relied on. So the assumption that they correctly link voice files and tests, absent of evidence at all, is, in my view, deeply unsafe. And the accusation of TOEIC fraud against any individual based on that evidence is, in my view, absent more, deeply unsafe. And the lesson of the post office cases is that they'll get away with it for so long, but only for so long. And in my view, eventually a reckoning on this is coming. I'm going to pass you over to Patrick now. Thank you very much.
Thanks very much. So I didn't actually attend any of the hearings. I had always meant to go and watch some of Varkey when it was going on. But anyone I know who was there said, it's in the bag, it's won. You would be allowed and overcome DK and RK. When that decision came out, it was such a shock, obviously for Greg and Alex, but everyone, as I say, said that they thought that it would have been allowed. So it's a huge tragedy that isn't what happened. But I still think, even with those decisions of DK and RK and Varkey, that these appeals can still be won. And I am still succeeding in appeals. The Home Office now seem to routinely appeal if we do succeed. But having said that, I've had decisions upheld as well in the UT. And really it comes down to preparation. If you're presenting, if you're preparing these appeals, the preparation that has to go into these cases is a very high level. And I think the first thing I always try and remind the judge in presenting these appeals is what is at stake. And in Shen, a case in which Justice Green, a case I quote in every hearing, is this: it must be recorded that a finding of dishonesty can have catastrophic consequences in social and economic terms. It is not to be found lightly. And that is what is before judges in these cases. These are accusations of fraud, of criminal behavior, And it does nearly every time have catastrophic consequences for the individual. And I think it's something that has to be really reminded, because judges, especially now with DK and RK, start on the basis of, well, it's not your client's voice. It's not your client's voice. That's the end of it. And it's not the end of it. It really is still, even though, and again, it's kind of the elephant in the room, and I'm comparing these appeals, you'd almost think maybe that Varkey and DK and RK hadn't actually been decided, because of course I acknowledge that what they both say is, if you get your recording and it's not your voice, well, that's compelling evidence, basically, that you cheated. But you need to look at DK and RK and Varkey carefully, because what they both say is that even if you get your voice for your recording, it's not your voice, it's never, ever, in my experience, the person's voice. Well, even if you get the voice and it's not your candidate, your client's voice, there still has to be a fact-sensitive analysis in each appeal. And so you start, of course, on the basis that the recording is not that of my client. My client is insistent that they did their voice. But you'll see the various parts of DK and RK where it emphasizes this. Again, we would not say that the evidence has to be regarded as determinative. If credible and sufficiently comprehensive, such assertions might perhaps, in an individual case, suffice to prevent the Secretary of State from establishing dishonesty on the balance of probabilities. And then similarly in Varkey and Joseph, again, the emphasis upon this need for the tribunal to consider the evidence before as a whole, for the tribunal to decide whether the respondent has established that it's more likely than not that the appellant has behaved dishonestly. And so what are the relevant facts? And I always again rely on this case of Majunda, which is a Court of Appeal decision, and identifies the relevant issues that need to be addressed in these appeals. And in preparing these appeals, if you're not represented, looking at these factors. So what the person accused had to gain from being dishonest? Well, the first thing, obviously, then is, and it comes in later, is looking at that individual and seeing what was it that they would have had to gain from being dishonest. And in most of the cases I've represented, it's very difficult to identify that. I mean, when the person's English is good, when their qualifications were high, they were getting qualifications at a much higher level than that was would be tested in these exams. And you've got to remember, this is not a difficult test. It's not a difficult test to pass. And so if someone's doing a level 5 diploma, their English is superior to what that was required to be able to achieve the test. But then it's what he had to lose. Now, the first thing is that the evidence is that people who were paying a proxy were paying between £500 and £750. I mean, that's a lot of money to lose to pay someone, especially if you've got a client whose English is obviously sufficient for them to have been able to do that test themselves. And it's an obvious factor to really focus on. And so I always call evidence about what they were doing. Everyone was working either 10 or 20 hours, the maximum number of hours they were allowed to work at minimum wage, giving rise to what an income would be, maybe £500 over a course of a month. So what they were willing to pay all of that money to someone to do something that they could do themselves. So clearly, first of all, financial, a huge amount to lose, but importantly as well, I always called evidence on their understanding of the consequences of, if they were to be found to committing fraud, that they understand the consequences that would flow from that. And that would, of course, mean, first of all, being removed. Secondly, being banned from being returned for 10 years. And then, of course, if they were hoping to go into business, going into other professions which would involve travel, not being able to travel to any other country. So that is a lot to risk, isn't it? It's a lot to think, well, shall I or shall I? Probably, if you can do it yourself, you're not going to pay someone that money and also bear those consequences. And then there's obviously what's known about the person's character. None of my clients have ever been accused of cheating in any of the other exams that they've taken. Significantly harder in any country that they've come from. But again, an important thing to, I'm not sure what this factor is. It's the cultural environment in which they operated. I don't know what that, I kind of skip over that one a bit. But, and then how the individual accused of dishonesty performed under cross-examination. Again, you've got to prepare your client. You've got to look and you've got to try and go through as much detail about taking the test, why they chose the test, how they booked the test. And of course, what you've got to remember is if you're accused of ETS fraud, you can't win. Because if you remember, how can you remember? You must be lying. How can you remember that amount of detail? Well, I've had a client who was asked, what time did you arrive for the exam? He said 9:30. How could you remember you arrived at 9:30? So you've got to prepare your client, you've got to think yourself through, why is it I can remember that? What is it that made me be able to remember something? And then of course, the whole issue about being able to describe what was undertaken in the exams, etc., what you had to actually do, what was the speaking test about. Again, if you remember too much, you're accused of lying. If you can't remember, well, the reason you can't remember is because you didn't do the test yourself. You paid someone, that's why you can't remember. So all of this are factors that you've got to have regard to. And then, of course, the assessment of the person's English language proficiency, is that commensurate with the correct scores, and whether his or her academic achievements such that it was unnecessary or illogical to achieve it. Again, most of the clients I've been representing have got very good academic achievements. Now, of course, there is in Varkey, again, as Greg has referred to, it makes reference to the fact of if an individual displays a grasp of English that is lower than that's required for the test, that's likely to weigh against the individual. Obviously, the converse must be true. But of course, the problem is that even if you have a client who speaks English really well, who's got qualifications, there's also authority that says, well, even if that's the case, MA says that the individual might still have an incentive to cheat. And that could be a fear of failure, a lack of time, nerves. So again, all of these issues are issues that you've got to address with your client to ensure that that can't be leveled against them. The fact that there might have been some other incentive for them to have engaged in cheating, even though that they would have been able to pass that exam without the use of a proxy, a very expensive proxy. And the other thing, of course, is that by the time your client comes to hearing, it's years since they took that test. And so then the obvious assumption that's always made on the basis that it has to be against the individual accused of fraud is that, well, how do we know your English was like then? Your English is good now, but you've been living here for another 10 years. So obviously your English will have improved. And so that means that we can't be sure, even though your English is very good on today in court, your English might not have been so good back in 2012 when you took this test. But again, if you think about it, for most of the people who are here still fighting, most of those clients have been unable to work, they've been unable to study. When they took that test, they were working, they were studying, they were socializing with people from the courses or from wherever they were working and using English as the means of communication. Those individuals, to be able to survive for this long, almost certainly would have had to have retreated back into their community. And they will be speaking the language whatever their community is. And so actually, many clients, their English would have deteriorated over this time. So this, again, there's always the assumption that's used against the individual is one that really isn't applicable. And so then we have this is the really strange thing, because of course what is clear, and as I say, DKRK Varkey is very clear, it has to be a factual analysis. You start with the assumption because of it's not your recording. But then if you look at the facts in DK and RK, they are quite strange, because what the panel says is about the need for the individual, but also very clearly placing huge weight upon the evidence of the recording. It then says this: in these circumstances, when you're looking at how does an individual be able to satisfy that they've given a plausible explanation, a plausible response to this accusation? This is what Mr. Ockleton said. He said this: in these circumstances, the real position is that mere assertions of ignorance or honesty by those whose results are identified as obtained by proxy are very unlikely to prevent the Secretary of State from showing that on the balances I've missed that they use fraud. Okay. Now, what does that mean? Because every single one of my clients is giving more than just mere assertions of ignorance or honesty. They're giving very clear accounts as to why this accusation has been made is wrong, and being given clear evidence to show that it should not be relied upon. And if you look at DK was a lorry driver. He didn't know where his test took place. He didn't know where it was. He couldn't identify where the test center was or where. And there are other facts about his case which maybe could have given rise to some suspicion. In our case, she'd taken another test. Now, I'm not making any allegations. I'm really not about those individuals. All I'm saying is that what was clear is that the panel went on in both DK and RK and looks at the facts of those cases. And it's on the basis of the issues that they identified, the inconsistencies, the illogical perhaps aspects of their accounts that led them to dismiss the appeal. And that's why I would suggest it's so important that you do always argue the case, but also look at the test. Is it more than a mere assertion of ignorance or honesty that's being put forward? And as I say, in nearly every case, it will be. Now, there's the National Audit Office report. Now, this, again, to me, was a fundamental report, because what happened in this was the National Audit Office, a very prestigious body, took evidence from ETS, took evidence from the Home Office, analysed the figures that was being provided to them, and they understood, they appreciated that there was this situation whereby over 97% of all the UK tests were identified as being invalid or questionable. And that is an extraordinary figure, because, of course, at the time when you had to take the English language test, there were 4 providers: Pearson, City and Guilds, IELTS, and TOEIC. You would choose any one of those randomly. There was no prestige by going to a particular college or a particular provider. But according to this analysis, it seems to be that everyone between 2011, when it first started, to 2014, when it closed down, nearly everybody has been identified by ETS as being engaged in suspicious activity. It's mad. It's Kafkaesque, isn't it? It's just so ridiculous that that can be. And yet, the attitude of DK and RK was to exclude this evidence. It was excluded on the basis that it attracted parliamentary privilege, the report, and so couldn't be cited. So it wasn't considered. But I've been very fortunate. I've had our researcher, Claudia Neal, who I'll be referring to again later, undertook research, and she was able to identify the way in which actually this evidence is admissible. And I use it in every case. And it's so important that it is something that, so it's DK and RK, the parliamentary privilege, the evidence but you'll see that there's cases in which where the evidence isn't considered to be controversial, then that evidence can be admitted. If it's uncontentious, the evidence can be admitted. And that is something that comes from, and that is something, there's a letter from Stephen Timms, from the National Audit Office to Stephen Timms, in which he identified the fact that this was, that there was no challenge to the evidence. So finally, I just wanted to talk again generally. I think it's really important to be able to identify ETS, especially given the evidence that we have from DK and RK, the way in which ETS was identified as being such a reputable organisation. It's anything but. It's anything but. And the evidence that is available shows that, in fact, the first of all, just one quote, and it's something that Greg has already referred to. But it's an actual quote. It's paragraph 23 in Varkey, and it's from the auditor, and it says this: he was told that management was sick of hearing about him telling them to close down centres, and he was not to bring it up anymore. I mean, that's the evidence from in Varkey about the conduct of ETS. But also, ETS has been shown to be an organisation that will try to prevent evidence being provided. And so, in 2008, there was a scandal with regard to SATs, and it led to a fiasco being described as one whereby it's called the biggest administrative failure to strike British education in recent years. It led to 1.2 million pupils' tests being cancelled. And then in the BBC report, it refers to this. The Conservatives, this who was in opposition at that time, called for government to drop ETS in time for the next year's exams. Shadow Schools Secretary Michael Gove said, every day brings new evidence of their serial incompetence. Ministers must act now to ensure that next year's exams are conducted properly. The Sutherland inquiry looks at the evidence with regard to ETS and was highly critical of it as an organisation. And what is, again, a consistent track of ETS is that in the Sutherland inquiry, they refused to provide documentary evidence. And again, that is regular conduct by ETS in these proceedings. There's a report from Chris Stanbury, which is a generic report. And in that report, he makes reference to the way in which ETS has been asked questions since 2015 and has failed to provide those answers to those questions. And he says this: I've been made aware that there was no response to the request for detailed questions about its data handling, and it said answers would have been very useful in determining what happened. In the absence of answers, I was sometimes forced to offer speculative scenarios based on the limited information I had to hand. And then, of course, in Varkey, he's criticised for entering into speculation. And so, lastly, I just wanted to talk about a case in which I'm involved in. It's a case called Post-Varkey, and it's a case in which the appellant's here today, actually. This is an important test case. It's one in which we are attempting now to obtain disclosure from ETS, and we've had directions issued for ETS to provide the evidence which has been sought for a number of years, and actual directions have been provided now by the panel. Now, this is largely focusing on the way in which, how can it be that nobody gets their recording? Nobody gets their recording whether they get an invalid result or whether they get a questionable result. It's still not the individual's recording. And the theories that have been put forward or evidence that's been put forward has led to questions. And this is something that's been very much focused on by Micah Neal, who has undertaken amazing work and has essentially come up with theories as to what could have led to the issues that have arisen. So it's highly technical, but ones in which the data which have been resisted, the disclosure of the data has been resisted by ETS until now, is potentially could be provided. But given their past conduct, I think we have to assume that they won't provide the evidence. And on that basis, again, I'm conscious of time. It is something in which the analysis has shown that there's a real risk that the data hasn't been retained by ETS, that the data could be retained in an anonymized form, which would mean that individuals could not be linked to the recording. There's also potential issues with regard to the way in which allocations of unique reference numbers were introduced around the time when this scandal occurred could mean that ETS would not be able to link the recordings with the individual, and various issues that have been identified as potentially occurring have been ones which ETS could provide a response to. They could provide the evidence, but to date they've simply refused to do so. And so the problem is that a number of issues could have arisen, but we just don't know because ETS is refusing to give the evidence. We have applied for third-party disclosure against ETS. That's been granted by the upper tribunal, even though they refused to comply with that. A narrower disclosure order has now been made, and that will require ETS to disclose material that's held here in the United Kingdom, only in the United Kingdom. The problem is that ETS is a Netherlands company, and so the only way to potentially obtain that would be in the High Court through a letter request, which would cost thousands of pounds. And ETS is very aware of the fact that we have limited resources, and so the potential of being able to obtain that disclosure is unlikely, but it's something that it is carrying on. But if ETS do continue to resist, what we have put on notice to the Home Office and to ETS is that we will be asking for strong adverse inferences to be drawn against ETS's credibility and to conclude that the evidence of the Home Office can't be relied on. So again, there is some hope in respect to these proceedings. They are ongoing and it's at an early stage still, but nevertheless, there is perhaps some hope of being able to get some disclosure. Thank you.
Patrick, that's very hopeful ending. Next, Alex is going to talk a bit about the evidence of the Varkey case.
Thanks, Greg. Good evening, everyone. I'm going to speak today and summarise some of the evidence that we heard in the Varkey case, which, as Greg explained, didn't make it into the judgment. Hopefully, some of this unused evidence will be useful for future cases, and it certainly sets the scene for future test cases before the other tribunal. There was a lot of detail in Varkey about the London College of Social Studies. Instead, I'm going to focus on the evidence of generic relevance. We don't have an official transcript of the evidence that was heard in Varkey. So these quotes are either taken from my note or Abby's much better note of the evidence we heard. So these were the four main witnesses. To summarise, we had Richard Shurey, who is a former ETS auditor. He was called by the Home Office as a witness for them, but as we'll see, effectively changed sides and gave lots of incredibly helpful evidence for us during the course of the hearing. There's Adam Sewell, a Home Office analyst, who was the Home Office's main witness. Again, as I'll explain, during the course of the proceedings, ended up giving quite a lot of helpful evidence for us and certainly wasn't a convincing witness. Chris Stanbury was our main witness and RIT expert. And then Andy Burns-Smith, he was effectively a police officer employed by the Home Office as part of their investigations into some of the colleges. It became clear during the hearing he really didn't have any sort of directly relevant knowledge for any of the forms of cheating we were looking at in the Varkey case. He doesn't really feature in the judgment, and I'm not going to discuss him in any more detail. Starting off with Richard Shurey. The significance of his evidence was that he was very critical of ETS processes at the time. So it was not just that in hindsight, 10 years later, he was turning around and saying, well, things could have been done better. But he was very clear that at the time, he'd been raising concerns to senior management about what was going on the ground. There was evidence from emails he'd sent to people raising his concerns that simply hadn't been answered. He certainly presented as a witness who was genuinely quite committed to the job he was doing. And we didn't really have much of a background in testing or auditing. He'd come in and discovered at ETS they weren't doing their jobs properly, and was concerned about what was going on. From reading the judgment in Varkey, it's very difficult to get the full flavour of Richard Shurey's evidence. The UT's conclusion as well, in hindsight, things could have been different. As we'll see going through Richard Shurey's evidence, the evidence was actually that at the time it was clear that things were not being dealt with properly. The first aspect in which Richard Shurey gave helpful evidence was about ETS as an organisation. He was very clear during his evidence that ETS couldn't be relied upon. He explained in detail how senior management didn't want to know about the cheating that was going on. When he was trying to raise issues, and not only were they ignoring him, they were effectively telling him to stop, telling him to stop contacting senior people within the organisation. We also gave clear evidence that part of the reason for that was that ETS was making a lot of money from these tests and from private centres that were running these tests, and that those financial considerations were placed above the integrity of the test. And moving on to the lack of effective auditing procedures. Richard Shurey gave evidence that ETS didn't have enough staff on the ground carrying out the audits, and also that they were using temp staff that weren't really able to do it properly. Then he went on to explain that it wasn't just that there was a lack of resources for carrying out the audits, but also that senior people within ETS weren't giving them permission to carry out sufficient audits. So it wasn't just that there were insufficient resources, which I suppose is going to be a common problem across all sorts of fields where things could be done better if there were more resources. But actually, even with the resources they had, they weren't able to deploy them properly because they weren't getting permission from senior people in ETS to carry out the audits. And the third aspect of his evidence was that senior people went beyond that and were actively disrupting the auditing process. And so firstly, that they were misreporting to the Home Office what was going on. And secondly, that very shortly before the Panorama documentary was broadcast, the senior management at ETS decided to stop the auditing completely. The picture from Richard Shurey's evidence about what was going on in the run-up to the Panorama broadcast is that effectively ETS system for auditing private test centres had completely broken down. They simply didn't know what was going on. Moving on to the administration of the test itself, Shurey gave helpful evidence about the scope for the potential methods of fraud that could be happening. There was some contemporaneous evidence that when Richard Shurey and other auditors had contacted YBM, the software producer, to try and get some information about what was going on at the time, YBM effectively hadn't been able to help. They hadn't really properly been able to grasp what was wrong with their software and the possibility that there might be widespread cheating. And then incredibly, YBM's response was effectively, well, as Greg explained, you can just get in people to run the tests who are going to be completely reliable and there's no possibility for cheating. And they told ETS that there wasn't really any possibility of using the software itself to prevent cheating. So given that evidence, it was clearly very important that ETS had a clear grasp on who was running these centres and how they were operating. But Shurey gave evidence that there were some completely unauthorised test centres that were running tests. This wasn't even just centres who were authorised by ETS to run tests but were not doing it properly, but also centres that from ETS's perspective weren't even meant to exist. They discovered this because one of their staff came across a flyer for a test centre in Davenant Street, which wasn't registered on ETS systems but somehow was running tests, and people were turning up and candidates thought they were taking tests at a genuine test centre, but in fact it was a complete fake organisation. But somehow these tests were still being reported into the ETS systems and were generating results. I've included here a summary from one of Richard Shurey's emails at the time reporting this sort of up the food chain to more senior staff. And it's very clear that even at that time, ETS knew what was going on. They knew that their system for running these tests was out of control. They had no idea what was going on. But apart from Richard Shurry himself acting as a whistleblower, trying to sort of raise these issues for senior people, no one was dealing with it. All of this evidence is in complete contrast to the position of the upper tribunal in DK and RK and then in Varkey. The ETS was a reliable organisation. It's really difficult to see how that conclusion could stand in light of what Richard Shurry said. And the final point that Richard Shurry accepted was that it was clear to him that innocent students would have been caught up in this. He was someone who had really direct on-the-ground knowledge of exactly what was going on, but still believed that it was quite possible that innocent people were being caught up. So moving on to Adam Sewell. So he was the main Home Office witness. He's worked in the Home Office for over 10 years as an intelligence analyst. The role in proceedings was very unclear throughout the upper tribunal hearing. The Home Office presented him as something of a semi-expert witness. So he was allowed to, by the upper tribunal, to give evidence about his opinion rather than as matters of fact, despite the fact that he doesn't have any particular expertise and he hadn't followed all the normal formalities for giving expert evidence before the tribunal. His evidence didn't go well, as we'll see. Greg caught him out on a number of points. And the upper tribunal made very limited reference to his evidence in the actual determination. When Adam Sewell gave evidence for pretty much a day of the hearing, but he's only referred to on sort of 4 or 5 points on matters which were from his witness statements rather than from his oral evidence. The first aspect of his evidence which was strange was that he kept making reference when he was speaking to mysterious further intelligence which hadn't been disclosed to us and those acting for Mr. Varkey. This happened several times during the first hour or so he was giving evidence. I've included, for example, one of Greg's interactions with him, where there's sort of amusement about what this further evidence is and why it hasn't been provided to us. And Adam Sewell's position as well, this stuff exists. I know all about these things that are going on. You should just sort of take me on trust. Obviously, that wasn't an acceptable response. After this had happened on separate occasions, the upper tribunal judges did intervene and asked Adam Sewell to clarify a little bit. And at that point, he wrote back and said, well, there is all this extra evidence which hasn't been disclosed, but I'm not going to rely on it. I'm just going to rely on what's been exhibited before the tribunal. But then towards the end of his evidence, he did go back and say, well, if this was a criminal trial, maybe there'd have been more evidence provided. So there was that lack of clarity, which wasn't discussed in the judgment at all. Then about the actual analysis conducted by Adam Sewell. So his analysis was effectively statistical analysis based on the data that had been provided to the Home Office. But when pushed on his expertise as a statistician, he conceded he wasn't a trained statistician, but instead he'd just spoken to statisticians to work out what was going on. And of course, we didn't have any evidence directly from any of the people he'd spoken to. We didn't even know who they were. So it's perhaps unsurprising in light of that the UT was reluctant to rely directly on the stuff he'd said. Having said that, there were all these problems with how he tried to bolster the Home Office's case, and we did concede a few things that were helpful to us. So importantly, he acknowledged that when the initial data about all of the voice files had been sent to the Home Office, but there are anomalies in the data that had been provided. So he gave an example of sort of dummy things in the data, like David Cameron being used as a dummy name. But there are also things about people's nationality being wrong and things like that. That the Home Office had no way of checking that data, so they received this data full of anomalies. Some obvious things like David Cameron's name being in it, they were able to clarify with ETS. There were lots of things that they simply weren't. And there was one particular issue on which we were able to get very helpful evidence from Adam Sewell, which was about the nationality data. That in Mr. Varkey's case, he'd been listed in the data from ETS as having his nationality British, when it was not. And Adam Sewell conceded that nationality was both frequently wrong, and because it was something that obviously the Home Office did have data on separately, they never relied on ETS's nationality data. when they were making accusations of fraud. So that raises the question of, well, if the data was so wrong on that point, why did they feel comfortable relying on ETS data in other aspects? Summary of Adam Sewell's evidence was that he made a few helpful points for us in his central arguments for the Home Office. The upper tribunal itself didn't feel able to rely upon. Finally, he gave helpful evidence about mass replacement of voice files. This is one of the methods of fraud which is identified in Varkey. And Adam Sewell accepted that this would happen without the knowledge of candidates, and also that it was a method of fraud that he himself thought was operating at the London College of Social Studies. The Chris Stanbury I'll speak about in a bit less detail, because his evidence is recorded properly in the tribunal's judgment, although they reach conclusions which we obviously don't agree with. This difficulty that Greg mentioned earlier in giving evidence was that ETS have never disclosed any proper information about how the test was operating on bats, because it was so out of control they simply didn't know. The upper tribunal very unfairly accused Chris Stanbury of engaging in speculation, but of course that was all he could do on the basis of what had been disclosed to us by the Home Office and by ETS. And the point was that at least Chris Stanbury was trying to provide an explanation of what might have happened and explain, whereas there was no one on the other side who was providing any kind of explanation for the method of fraud that was meant to have been taking place in Mr. Varkey's case. So to conclude on the summary of the evidence in Varkey, by the end of the hearing, the Home Office's main witness, Adam Sewell, his evidence was in tatters. Their second witness, Richard Shuri, had in effect turned into one of our witnesses and gave lots of helpful evidence for our side. And it was very surprising that in light of that, the upper tribunal decided the case the way it did. It was almost as if the evidence we'd heard hadn't happened. I'll now hand over to Shana.
Good evening, everyone. Myself, Shana, Shaikh, one of the Liberties. Sorry, I'm late because I was in the other meeting, which we were waiting for last more than 6 months, and that meeting was with the Immigration Minister, Seema Malhotra. For that, we were waiting for such a long time, and we discussed quite a few points, and she seems like promising. Again, she needs to look at the the data and stuff, as just Patrick discussed about the voice recording, that none of the voice recording there on their own, like students their own, and she was a bit concerned about that point specifically. So yeah, we're wishing all the best to every student who is struggling, and we always thankful to you guys, Cardinal Co-Chamber, and all the barristers who has been so dedicated since more than a decade, I guess. We have done a fantastic job, all of us. And today, wherever we reach in a legal terms, I would say there is a huge contribution, Cardinal Co-Chamber and all the barristers. And Patrick is personally dealing with my case, and we have hopefully very soon we have some good news as well. So yeah, we're wishing you guys all the best. Keep doing it. Thank you so much.
Thank you very much, Shana, for that. We wish you the very best of luck in your fight. Finally, we have Abby, who's going to talk a little bit about the post office scandal and what we might have to learn in the TOEIC field from what happened there.
Thanks, Greg. So the Post Office Horizon scandal has been described as the largest miscarriage of justice in modern English history. As most of you will probably already know, it involved hundreds of sub-postmasters being prosecuted and accused of fraud or false accounting based on incorrect information from the Horizon computer system. The ITV drama released last year obviously prompted a national conversation about this issue, and the struggle for adequate compensation continues in the courts, and the inquiry report is eagerly awaited. But today I'm going to talk about some of the similarities between post office cases and the more recent TOEIC litigation, which I think provides serious cause for concern given the ongoing fallout from the post office cases. So the similarities in particular that I'll be going over are the computer evidence and the presumption of accuracy in the courts, the issue of non-disclosure and the unfairness that that poses to the individual, and the evidence of institutional obstinacy. So at the core of the injustice in the post office cases was the initial refusal of the courts to look behind the post office's assertions that the Horizon system was reliable. You'll see on the screen a quote from the CCRC in its first referral of criminal convictions in the post office case to the Court of Appeal, where it stated that for many years, the foundation of the post office's prosecution of sub-postmasters, managers, and counter assistants was that the data produced by the Horizon system was accurate and could be relied on. The presumption of accuracy spanned both the criminal and the civil courts, and I've included there a quote from the now infamous case of the Queen Anne Castleton involving Lee Castleton, who was, of course, left homeless and bankrupt from defending the litigation. In that case, His Honour Judge Richard Havery QC held at paragraph 4 that since Mr. Castleton accepts the accuracy of his entries in the accounts and the correctness of the arithmetic, and since the logic of the system is correct, the conclusion is inescapable that the Horizon system was working properly, and in all material respects, the shortfall is real and not illusory. The criminal context is also shown there in the Court of Appeal decision in Josephine Hamilton and others versus the Post Office, where it was held that by representing Horizon as reliable and refusing to countenance any suggestion to the contrary, the Post Office effectively sought to reverse the burden of proof. It treated what was no more than a shortfall shown by an unreliable accounting system as an incontrovertible loss, and proceeded as if it were for the accused to prove that no such loss had occurred. So there was a sea change in the approach to computer evidence in the Post Office cases, in the case of Bates and others and the Post Office, where Mr. Justice Fraser gave his Horizon issues judgment. So this was the 6th judgment in a long-running group litigation between a group of sub-postmasters and the Post Office. The case settled after this judgment, although of course the injustice is still often remedied. The judgment specifically addresses the operation and functionality of the Horizon system. It's not a quick read. It is 1,030 paragraphs long. Fraser J. described how, obviously this was far from ideal, how long this judgment was, but the reason was that it deals with the life of a complex that spans some 18 years, and he didn't shy away from that task. He wasn't content to rely on the Post Office's very high-level overview of Horizon by its expert, which he viewed as amounting to little more than a claim that it worked quite or very well most of the time. He also emphasized the importance of analyzing the IT system itself with the assistance of expert evidence, as well as contemporaneous documentary evidence. So this approach, of course, stands in stark contrast to the approach that you've all heard about tonight in DK and RK, and more recently in Varkey. In DK and RK, there was no direct evidence from ETS, and as Greg's already explained, the generic criticisms of ETS procedures were rejected, leading the upper tribunal to conclude, as you've already heard, that the evidence currently being tendered on behalf of the Secretary of State by ETS is amply sufficient to discharge the burden of proof, so requires a response from any appellant whose test entry is attributed to a proxy. And in Varkey, the quote on the screen is part of the judgment where it deals with the submission on the Post Office point that was made. And the upper tribunal, you can see, agreed with the appellant's submission that the Post Office litigation underscores the need to treat computer evidence with caution and not to assume accuracy. However, for the upper tribunal, that was the limit of the analogy. They found that the fraud here is not established by some glitch or bug or malfunction or manipulation with the hardware and software operated by ETS, but by positive steps taken to manipulate the test results by those charged with administering the test by ETS and the candidates taking the test. The problem with this position, as Greg has already outlined, is that it fails to acknowledge the expert evidence which was before the tribunal from Chris Stanbury, as Alex has just covered. So, for example, the possibility of mass replacement of voice files, the lack of any reliable evidence on the chain of evidence in the test that was taken to the voice files obtained years later, the backdrop of ETS failures internationally and the evidence on YBM, and it not fully understanding how the system could be circumvented. The next area of analogy with the Post Office litigation is the lack of disclosure. So in the Court of Appeal decision I've mentioned earlier of Josephine Hamilton, it was held that denied any disclosure of material capable of undermining the prosecution case, defendants were inevitably unable to discharge that improper burden. And similarly, in Bates and others, Fraser J was incredibly critical of Fujitsu's evidence and stated at paragraph 543 that the majority of the Fujitsu witnesses were more interested in following some sort of Fujitsu party line than they were in answering questions in cross-examination wholly and frankly. I think he also referred Fujitsu to CPP, possibly for perjury. So perhaps in light of these issues, later on in the judgment, Fraser J cites with approval the judgment of Lord Justice Mayles on the screen there in the Metra, where he stresses the importance of contemporary documents as a means of getting to the truth, not only of what was going on, but to the motivation and state of mind of those concerned. And that applies with greater force to internal documents, emails, instant messages, as those tend to be documents where a witness's guard is let down. While there's no suggestion that the witnesses were not being candid with the tribunal in DK and RK and Varkey, there was a notable absence of disclosure or participation from either ETS or YBM. In DK and RK, when addressing the lack of evidence from ETS before it, the tribunal stated that there's nothing in the material before us in the present appeals to suggest that the lack of evidence directly from ETS ought to raise any suspicion that evidence that might exonerate the appellants is being concealed. And again, in Varkey, neither ETS nor YBM were party to the litigation. The only witness from ETS was the whistleblower Richard Shuri. As Alex has already covered, Adam Sewell's evidence was that the Home Office had also failed to disclose relevant evidence, relying on the vague excuse of this being for intelligence reasons. So taking a step back, it's obvious that the non-disclosure by these institutions is it causes a serious prejudice to the individuals seeking to clear their names. Just like the sub-postmasters, they're denied the opportunity to access material potentially capable of supporting their case because of what is essentially corporate gatekeeping. Finally, there is an analogy, I think, to be drawn between the Post Office and ETS's reluctance to properly investigate alternative explanations for alleged frauds. So in Bates and others, Fraser J noted the Post Office's simple institutional obstinacy, refusal to consider any possible alternatives to their view of Horizon, which was maintained regardless of the weight of factual evidence to the contrary. He described this as amounting in reality to the 21st century equivalent of maintaining that the Earth is flat. So in the TOEIC litigation, there was evidence of similar institutional obstinacy, which was arguably compounded by the tribunal's decision. Greg's already referred to this passage from DK and RK, where the tribunal held that it is, in our view, inconceivable that ETS would retain the work that they do if it was thought that their administration was in this respect unreliable. ETS being a responsible body with clear interest in securing the integrity of results. In Varkey, Alex has already covered the evidence of Richard Shuri, which supported the view that there were institutional barriers in place at ETS in explaining the broken auditing system, the financial considerations being placed above the accuracy of tests, and that senior management simply didn't want to know about the cheating. So in light of this damning evidence, the tribunal's conclusion is surprising at paragraph 89, that the issues in relation to the manner in which ETS Global internally addressed the concerns regarding the fraud does not, in our judgment, impact upon the integrity of the audit trail in which the voice recordings are attributed to candidates. So overall, I think looking at the decisions in DK and RK and Varkey in the shadow of the post office scandal is an instructive exercise, which really elucidates the dangers in the approach taken by the upper tribunal, and hopefully time for reckoning isn't as far away as the victims of the post office scandal had to wait. Thank you.
Thank you very much, Abby. I think we've got a couple of minutes for questions if anybody wants to ask anything before we go and forward to the hub for some things.
Has anybody attempted to get a file from ETS which relates to the 3% of people who were told that they had passed the test? So a reference file effectively for auditing or
I don't think anybody has attempted specifically to do that, but it'd be quite hard in GDPR terms to ask for the test results of somebody else, with their voice to be on for a start. But we have asked ETS for endless volumes of stuff over and over again. And you get a response from Jones Day. Lee Copy is the guy who sends it an email. The email says, ETS is not a party to your litigation and does not have to answer your various interrogatories. That's what the email says. So we basically have been stonewalled in everything we've asked for. I don't know if anybody's actually specifically asked for that. I'd be surprised if anybody felt in a position to disclose that, to be fair. But we get nothing from them, literally nothing.
internally that would be a starting point for an IT audit though, because you'd have the file that's actually supposedly right and then compare it to the ones that are wrong. But if the file that's right is also the wrong one, tells you something.
Yeah, well, I mean, one thing Patrick's talked about is that you have got 98% of people where their question were invalid. In the tests, the cases I've done, if you've got a client who's got one questionable result and one invalid result, it's often people have done a couple of these tests. Questionable, invalid, whatever it's called, it's never their voice, never. And my view is they can't connect them properly. I think the whole thing's unreliable.
Asking for one that has passed might be a useful thing to do if it were possible to ask.
I don't think there's any way of tracing through the system to check if it's right, but certainly we don't know. There is no evidence whatsoever in support of the proposition that ETS correctly attributes voice files to individuals. Like, never get it.
And so that is why this case up with Post-Varkey is important, because we have got a direction where we are looking for disclosure now from ETS. They've got until the 4th of April to be able to respond, but it would only be evidence that they hold here in the UK, which is likely to be very limited. They might be the recorded, we don't know, and it would be interesting to see if they do respond. And then, as I say, the whole failure of ETS to be able to provide evidence and to respond to these requests. I mean, the problem is that they've never been held responsible for that. This case is quite interesting because I think what the intention was of the tribunal was to close this down once and for all. If it's your recording and it's not your voice, then that's the end of it. You shouldn't be continuing with these appeals. And that was the intention. I hope we've stopped that from happening because of the way in which ETS have refused to disclose anything to us. And now we've got an order whereby it'll be interesting to see what their response is. But all these questions are questions that have been put to ETS about their internal procedures, about the way they've been storing the evidence, data, the metadata, and hopefully, well, we'll see what we get. Right now, we've had nothing. Greg says they refuse.
Just want to thank all the panelists and you guys for coming along. It was really important to me personally anyway to try and get what happened in Varkey out there in public. Thanks especially to Shana for coming along, and we all wish you the very best with your battle. If you enjoyed this event, please visit our YouTube channel. Thank you.